Greetings and welcome to Agency, Practice and Procedure. We're going to be going over actions and remedies, pleadings, evidence, and questions of law and fact. But before we do that, just to remind everyone, this is strictly for the educational entertainment purposes of this YouTube channel and broadcast, not to be used, abused, or misconstrued for anything legal, lawful, public, private, personal, financial, tax, business, or otherwise. Just don't do this at home. Let's proceed. And for those of you that have just arrived, welcome. And I just want to let everyone know I do have the talking chat enabled. So if you type something in the chat, it'll read it back.
The prompt says, hit the like.
Indeed. So this way we can interact and answer any questions, have any clarifications or comments as we go along. Let's get started here with the first section here under practice and procedures from the American jurisprudence on agency. And we're going to first go over actions and remedies in general and the actions and remedies of the principal against the agent. Come on, there we go. Okay, so starting with section 320, generally here, the principal may sue the agent, 1, on contract for breach, 2, in tort for damages, or 3, for money, property had and received. So as you see here, the practice and procedure manuals from American jurisprudence are basically explaining how to properly construct, pleadings or actions, etc., or how to defend, etc. So you're looking for best practices, defects, anything like that, and they're all going to be highlighted. So let's follow through here. So the principal, here's the 3 things that he may sue the agent: either contract for breach, so suing on the contract; in tort for damages, some kind of intentional harm or something of that sort; or 3, for money or property that they had received, so as a debtor. Where breach is also a tort, principal may elect to sue in contract or in tort. And as we learned, you got to choose which type of action you're going to be suing in when there is something that has caused harm. Is it because of the breach of contract, or is it because that their breach of duty as part of the contract? So these little fine nuances are really what make or break a case. Equitable remedies, such as constructive trust, injunction, accounting, and rescission of agency agreement. So these are the remedies in equity that you can have through these types of agency actions, right? This is actions when the principal is against the agent here. So there's remedies for when they're harmed by the agent. The equitable remedies would be a constructive trust, meaning that a trust, things like this, even in a bankruptcy or something, where it would be administered by a third trustee. An injunction, which would be preventing them from continuing to perform in such capacity or such. Accounting, demanding records. Rescission of agency agreement, so the whole voiding of the contract in essence. The agent's liable for all loss from breach of duty, including payments principal made to third parties due to the breach. So if the principal made payments to a third party because of the agent's breach of the contract or the breach of duty, then the agent is still liable even for those payments made. So these are the essences of constructing an action, and the pleadings and such would be that take account of all these. These are the general actions and remedies we're going over here. This is the outline of what would be you'd use to express these things, where they could be treated by a court and litigated to where there could be a remedy prescribed. All right, we have a mere creation of agency does not establish the agent's responsibility for the principal's emotional distress. So the mere creation of the agency does not establish the agent's responsibility. So we get into the tort for the intentional harm from emotional distress and these kinds of things, or intentional infliction of emotional distress. It can't be caused merely by the creation of the agency, just because they had a agreement with a particular agent. Where agent profits from breach of duty, principal may recover those profits. This is interesting here. So where the agent profits, so that calculation, that's where you have to have that accounting. So let's look at these supplement cases here. We have Burbank Grease Services versus Sokolowski. That was Wisconsin 2006. A claim for the breach of an agent's duty of loyalty may sound both in tort and in contract. So this would be interesting here, and at least in Wisconsin, that's been upheld. And then we have GAB Business Services versus Syndicate, and that's when this 11th Circuit, 1987. When a paid agent acts negligently, causing principal to become liable to a third party, the principal may bring an action against the agent, either in tort or for breach of contract. So both or. And you have two cases here to look at to see the details of which way to go. So as you can see here, just from this opening section here generally, you get a pretty clear outlook of what remedies and actions the principal can be categorized in using. But we're going to get in a lot more detail than that, so hold on. Here's our section 321, the action for accounting or for breach of duty to account. Equitable accounting available only when the agency transactions involve fiduciary features beyond the bare principal-agent relationship. So there has to be when the agency transactions involve fiduciary features. And then also available where there are mutual accounts or accounts of a complicated nature. And of course, not barred by latches where agent's fraud prevented principal from learning facts, and agent is not harmed by delay. So latches would be a lapse in time. So it's not barred by a lapse in time where the agent's fraud, of course, fraud, prevented the principal from learning the facts. And the agent is not harmed by the delay. So, just because there's a delay in bringing the action, that delay is not causing harm. If it is, then it may be barred by latches, but that would be something under something very complicated, probably statutory. It's not available where principal claimed misappropriation, but records were all in the principal's possession. So that's where we bring that accounting records. Agent need not be sued in equity for accounting. It may be sued at law upon the obligation. So the suing in equity is when there isn't a remedy, normal remedy in law there, and it's also used where it's something that can't be prescribed easily by law. So the injunctions, things like that, rescissions, that would be done in equity, but it need not be done that for accounting, but it can be. But let's look at these supplement cases here. We have Sokoloff versus Harriman Estates Development in 2001. If agent receives anything as a result of his violation of a duty of loyalty to the principal, he is subject to a liability to deliver it, its value or its proceeds, to the principal. And that comes from our restatement, second of agency, section 403. And of course, we have to pay our due respects to one of the originators of doing these restatements of law, illustrious Samuel Williston there with his piles of files on his desk and volumes of books back there to be able to condense things as complicated as agency law into these fine restatements. I think they're on the third. They've done the third. I'm not sure if they're doing any beyond that, but this was back in the 20s when this whole thing was started by the American Law Institute to bring all this body of case holdings, laws, statutes, codes, all together to where the practice really applies across the board, in the most I guess, fundamental ways, so they could be used across jurisdiction and used to help judges really to come up with consistent rulings, and also to assist practitioners in their pleadings and such. Nonetheless, let's get back to the presentation here. We have the action for money or property of principal in the agent's hands. An agent has a duty to repay or deliver principal's money or property received while conducting agency business. The demand is generally required as a condition precedent to suit, unless the agent is already in default. So that could be a time schedule. They're supposed to make a deposit and they haven't. If not, the demand is generally, remember, generally, except this one here, and I'm sure others, but demand is generally required as a condition before you can file suit. So again, we're talking about practice and procedure here, and this just makes everything go more smoothly. We have here circumstances may exist that impose a duty to pay and dispense with the necessity for a formal demand. So circumstances may exist. So as we see here, generally is presumptive. There's exceptions, and circumstances may exist that impose a duty to pay and dispense with the necessity for a formal demand. In this case, that's how it may be. In an action to recover money paid to agent by third person for principal's benefit, the third person is not a necessary party defendant. So the defendant is going to be here just the agent. In an action to recover money paid to agent by a third person for the principal's benefit. So the third person, by paying the agent, doesn't make him party to the action to recover. Necessarily. You got to put that in there. All right. Let's get on to section 323, the limitations of actions now. Commencement of limitations depends on when the agent's duty arises. So as we saw here before, demand may not be necessary. It depends on when the agent's duty arises. Turns on contract terms, remember the scope of authority and things like that, custom and circumstances, or character of agency. Where contract fixes a definite time for payment delivery, statute begins to run at that time. So the contract, again, fixes a definite time. That's why the specificity is so important. The statute begins to run at that time. So we see here that the commencement of limitations depends on when the duty arises, right? Well, this is if there's a defined time, it would run at that time. But as we saw here, it turns on contract terms, right? So it may be in the contract terms where customs, there's circumstances, maybe there's a holiday or something, so that commencement would be delayed, or character of agency, maybe because it's a certain skill of the agent that they would be expected to do it sooner than someone else. There could be a whole variety of reasons. So let's look at some of the competing views and when the statute commences to run. When the agent receives the money or property of the principal. When the principal has actual or constructive notice of the fact. So let's say he has a bank notice that normally comes to him, and the bank notice would have it clearly defined. So then he would have constructive notice, perhaps. In that situation, no one notified him of the transaction, but he was aware of it or was able to have knowledge in a reasonable person or in a normal circumstance, he would know. So when the principal has actual or constructive notice of the facts upon which right of action is based, that's when the statute commences to run at the time of demand by the principal, as we said here before, at the time of demand, when the agent renders or offers to render an account. So they offer to render, that's when it starts. After a reasonable time, when nobody's defining anything here, and after termination of the agency. So these are the competing views when the statute commences to run. Now, fraudulent affirmative act concealing collection. So here's an important term here, concealment. The statute does not run until principal discovers the fraud. Now, one court says the statute for civil actions not otherwise provided for applies to breach of fiduciary duty claim against negotiating agent. So check your jurisdiction. So those are your limitation of actions. You can see all these competing views and, of course, issues of fraud. It does not run until the principal discovers the fraud, which is across the board pretty much with fraud. All right, let's move along here. Now we're on to section 324, liability of agent as dependent on loss or damage. So an agent who violates the principal's proper instructions is responsible for all loss or damage that naturally results from the agent's acts. So without any further input from the agent there, the damage naturally results. An agent may escape liability by showing, 1, no loss or damage resulted from the disobedience. So the disobedience alone isn't enough. Or 2, the disregard had no causal connection to the loss, and loss would have occurred even if the instructions had been obeyed. So there's a burden of proof for the agent to escape liability. So understanding this, if it was a principal, just to know that these need to be covered because these are the defenses to be looking for. If there's an agent that is being sued when there really shouldn't be, then they have the burden to prove these things here, absent any other kind of evidence. And these are your 2 ways the agent may escape liability. Now let's look at some of the agent's defenses and right to set off or counterclaim. An agent may defend by showing compliance with the principal's own instructions. Of course, that would work. Liability may be avoided or reduced by the principal's breach of contract, contributory negligence, fault, or failure to mitigate damages. So if the principal is doing any of these things, that liability may be either avoided or reduced. Defense of illegality of employment or of the transaction. So of course, public policy, illegality, that would make those instructions, the agent could not be liable then. Restatement second, defenses. Here we go. Incapacity. This is your agent's defenses. Now, I couldn't do it because of impossibility, incapacity, statute of frauds. So statutes of frauds is not a particular statute or anything like that. It's a term, I guess you could almost say a term of art that refers to any kind of rules or in cases where there are statutes that specify the limitations of oral agreements because they're not expressed, that they don't have that same weight and they have a higher burden, that they standing alone don't really constitute the full weight of the evidence as a written instrument would or a written agreement. So although they are still valid, whenever there is a dispute, the statute of frauds comes into play to show the limitations of those oral expressions as opposed to written ones, which are easy for the court to deal with. All right, let's look at the ratification by principal. So these are the defenses. It was ratified by the principal. Privilege to protect superior interests. We saw that too with the agent. If it's, there's a certain amount of discretion and there's an order to do things. We use the pipe bursting example there to see the nuances involved in that. There's release or discharge where they're relieved of their obligations. The agent was relieved of obligations, so that would be a defense of been discharged. Bankruptcy, criminality of the act, and that's in accounting actions. So you're asking the bookkeeper to do something they shouldn't do, then they can't be held liable. That's a defense for the agent. Then we have the set-off counterclaim. In a suit for money collected, the agent may deduct services or expenses related to the subject matter. So the set-off or the counterclaim, the set-off would be the differences that may be deducted, and what's remaining would go to the principal. And another defense is the principal's acceptance and retention of partial payment does not constitute accord, and satisfaction precluding recovery of the balance. So even a partial retention is not a good defense. So we look at the all the defenses at work here, but the principal's acceptance and retention of partial payment does not constitute accord. So just because some of the money was given to the principal, that action might still be there. It'd be, you wouldn't defend it by saying he took part of it, because that would not constitute an accord and satisfaction, precluding a recovery of the balance. That balance is still due. So here's a bunch of other defenses. There you go for the agent. Let's see here. Oops, one more. All right, now we're on against the third person. So when we have, besides just principal and agent involved here, now we get actions and remedies of the principal involving the third person now. Generally, a principal is entitled to the same remedies against third persons as if acting personally. Undisclosed principal may sue on authorized contract, even though not named in it. Of course, you need to show that there's a power of attorney for that, etc. But even though they're not named in it, because it was an undisclosed principal. Now, think of this for privacy matters. This comes in pretty handy when you think about agency and agent-principal relationships and authorized contracts. Then there's a right of action for implied warranty or fraudulent representations made to agent belongs to the principal. So this is interesting here. The right of action for implied warranty or fraudulent representations made to agent.
Lex Animatus as an agent shall not bear false witness to create an administrative agency order to separate a father from the son. Lex Animatus as an agent shall not bear false witness to create an administrative agency order to separate a father from the son.
Yes, indeed. And actually, we're going to be getting into that. I'm glad you're here, because this is where we, the culmination of all the series of agency, where we're looking at practice and procedures. And we're going to touch on to about every aspect you can imagine for anything involving agency right now in this episode. And let's keep going. So as we see here, this is against the third person now. The principal is entitled to the same remedies as if acting personally. The undisclosed may sue on authorized contract even though they're not named in it. The right of action for implied warranty or fraudulent representations made to the agent. So a third party made implied warranty or fraudulent representations that need to be, there needs to be some kind of action. There's a dispute involving this. Well, that belongs to the principal, the right of action. The right of action. Then the principal may maintain replevin against third person who received principal's property via agent's wrongful disposal, where bona fide purchase rules do not protect the third person. Okay, so let's break this down. The principal may maintain replevin against a third person who received principal's property via agent's wrongful disposal. So the replevin would be where typically it's returned to him pending the outcome of the case. Sometimes bond's required, but it's a pre-litigation remedy, or what you have it to. There's no harm by returning the property to the principal until the trial is conducted. And until then, of course, the principal would agree that if they lose, they have to return the property to the whoever was disposed with. But nonetheless, this here is that the principal may maintain the replevin against a third person who received the principal's property. So again, the principal is maintaining this action here, the replevin, against the property. Against the third person. But it's based on the agent's wrongful disposal, where the bona fide purchase rules do not protect third person. So check your statutes and all that when it comes down to third person's purchases, and depending on what type of merchandise and such it might be. Nonetheless, a principal may maintain the action. And it says here may, so it doesn't say must. So perhaps he could have power of attorney, the agent could have power of attorney to do that for him. Then the principal had no standing to enter a separate lawsuit to assert cross-action defenses to a third party's claim against the agent. So the principal had no standing to enter a separate lawsuit to assert cross-action defenses to a third party's claim against the agent. So, yeah, I guess you can't gang up from two different suits in the same party. All right, so we have supplement cases here. We have got the Shrama versus Vinmar International. That's Texas Appellate Court there, 2007. A principal has standing and capacity to raise its own claims, even though an agent entered into the contract that is the basis of the claim. So the agent was acting to go into the contract, but the action now to sue for whatever failure to perform that contract that the agent entered for the principal for, that the principal is the one that has standing and capacity to raise its own claims. So the agent needs to step aside on that. Let's move along here to third person's defenses and right to set off or counterclaim. So again, we're looking at practice and procedure. You have to look at it from both sides. This is supposed to work for no matter which side you're on. There's something in here for everyone. When sued by a partially disclosed principal, partially disclosed or a disclosed, the third person has all defenses available as if principal had made the contract under the same conditions. So if the principal is disclosed, his name is known, or partially disclosed, the third person has all defenses available. If principal was disclosed at time of contracting, third person cannot set up defenses that only would have applied against the agent personally. So they're trying to take the agent personal's capacity, not in his agency capacity, but that would fail. They cannot set up defenses if the principal was disclosed at the time of contracting. Wow, that's pretty intense there when you look at this. When third persons are involved and there's an agent contracting for the principal here, the defenses here, if the principal was disclosed, but if it's, let's continue here. Third person may set up agent's fraud as a defense. A principal cannot reap benefits of agent's fraudulent transactions. Ooh, that's a good one there too. And the principal may not assert agent's unconscionable conduct as a bar to equitable relief unless a principal has knowledge of the wrong. Wow. So the principal may not assert the agent's unconscionable conduct as a bar to equitable relief unless the principal had knowledge of the wrong. Wow. So, interesting there too. Let's get on to the cases involving the undisclosed principal now. The third person contracting with agent of undisclosed principal. The third person may assert any defenses and equities that could be set up against the agent if agent were the real principal. So now when the principal's undisclosed, the agent's on the line fully now. Third person may set off a personal debt owed by agent when sued by undisclosed principal on the contract. So now the agent, if there's a personal debt that the agent owes this third person and the principal comes to sue the third person, then the agent, the third person may set off. They can say, well, we owe your agent, or your agent owed us this much, so we're going to reduce what we owe you by that much. That's your set off. Agreement to cancel agent's debt in exchange for services is not effective against principal if made after the principal's disclosure. That disclosure. So agreement to cancel agent's debt in exchange for services is not effective against the principal if it's made after the principal's disclosure. So again, by keeping it undisclosed, it's all on the agent here, it seems. Good faith payment to agent, believing agent was acting for himself, is a valid defense against the undisclosed principal, because you can't check in and say, is this guy really acting for himself, or is a good faith payment to the agent he paid the agent. Now some guy comes out undisclosed. That's a valid defense for the third party. And defense or set off against agent must have existed at or before time of disclosure to be available against the principal. So you're either going after the agent, and if the principal's involved, now whatever you pay the agent can be offset to what you would owe a principal, or whatever the agent owed you could be offset to what you would owe a principal. That's what the set off would be. And a party who knew of the agency or was put on inquiry and could have learned of it with reasonable diligence cannot claim the undisclosed principal defense. So we think of constructive notice here, something like this: could have learned of it with reasonable defense. The party who knew of the agency, had actual notice or constructive notice, cannot claim the undisclosed principal defense. So there it is. Pretty intense there for the cases involving the undisclosed principal. All right, now it takes us on to part 2 here with the actions and remedies of the agent. Okay, now we get actions and remedies of the agent against the principal. Section 329, the agent may sue the principal for breach of contractual or quasi-contractual duties. So things that aren't quite in the contract but probably expected. Actions available at law for compensation damages. Exercise lien rights. You can sue for accounting. So we have you have actions at law for compensation and damages. So you're looking for your property monetary type of thing here. Then you can exercise lien rights too and sue for accounting. The wrongfully discharged agent has a right of action for damages governed by employment contract breach rules. So we know how complex that can be there, but if they're wrongfully discharged and they had an expectation, they put aside other obligations or opportunities, then that's governed by those contract breach rules. Damages computation, here's how we do it. We deduct the proper business expenses plus the agent's subsequent earnings or amounts reasonably earned at similar work. So as you see here, we have here the wrongfully discharged agent has a right of action for damages that are governed by the employment contract breach rules. And then we do our computation. We deduct the proper business expenses plus the agent's subsequent earnings or amounts reasonably earnable at similar work. So expenses and what it's worth there. Elements of damages for the principal's breach. We have commissions on sales made in violation of exclusive agency. Contract market price difference for failure to furnish goods. And expenses payments made in executing the agency. So these are the elements of damages for the principal's breach. This is how you get to come up with a number, and the agent is going to have to say, well, there's commissions on sales that are made in violation of an exclusive agreement. You have the contract market price difference for failure to furnish goods. So if the principal was supposed to furnish goods or a price difference, who knows? And the expenses and payments made in executing the agency. So doing the duties and obligations of the principal, and the principal breached their obligations, then these are the elements of damages. The agent is not entitled to specific performance of the agency contract. So you can't force specific performance. That's not available, as we saw also in the contract law live streams. You can check that one out too. We're on to section 330, the principal's defenses and right to set off or counterclaim. The principal may defend on illegality of agency agreement or services rendered, violation of statutes of frauds, disloyalty, or insubordination of agent. So, if the agent's done any of those, Bad news. Then we have the restatement second. The agency's claim or the agent's claim may be terminated or diminished by release discharge by contract, the principal's discharge in bankruptcy, a set-off or counterclaim, judgment rules, co-obligor discharge, statute of limitations, or latches. So those claims may be terminated, time, of course, being the last. In action for compensation, principal may assert by counterclaim losses from the agent's unfaithful discharge of the contract on which agent sues. So the counterclaim losses. So yeah, it's defenses both ways. You see where the rubber really meets the road here in the practice and procedures here with American jurisprudence. So let's look at against the third persons, the remedies for the agent. The agent for disclosed, the disclosed principal generally has no right to sue third person who fails to perform on the principal's contract. Remember, he's been disclosed. The agent now is stuck just doing what he was supposed to do with the original terms of their authority. Agent with beneficial interest may sue in his own name, but mere entitlement to a portion of proceeds as compensation does not create such interest. Mere entitlement to a portion of proceeds, so it has to be a real beneficial interest. Agent who executed contract so as to be personally bound may sue in his own name, even if principal was disclosed, but executed the contract so as to be personally bound. So you're stating in the agency that you're personally bound to the actions. Then even if the principal is disclosed, the agent may sue in his own name. An agent who assumed the position of owner of goods may sue in his own name. Assume the position. And we saw, I think we're going to get it more into this. Agent may sue as trustee of express trust under statutes providing such exception without joining the beneficiary. Look at that. So the agent may sue as a trustee of an express trust, and that's under statutes providing such exception without joining the beneficiary. So this is important there. Now the agent cannot bring action for third party's tort against the principal unless the third party's actions were intended to harm the agent's interests. Interesting there. The agent's interests. So again, agents with beneficial interests may sue in their own name. All right, let's continue here. Agents who mistakenly pays third person principals money may maintain action for money had and received to recover it. So the agent who mistakenly does something can recover that in his own name there. Alrighty, we're on to the third person defenses and right to set off or counterclaim. So now the third person has all defenses except agent plaintiff as would be available against the principal, except procedural defenses based on the principal's personal incapacity to maintain the action. So the procedural defenses, third person has all those defenses, but they can't use the defenses based on the principal's personal incapacity. They can't say that's their defense. So in contract action by agent for partially disclosed principal, the third person may set off only claims that could be set off against the principal. So the difference is, like we saw there, how we calculate that. Agent who acquires beneficial interest in a contract is subject to the same defenses by the other party as any assignee of that contract. So there's your third person defenses there. You can see this is all in alignment with the same way with a disclosed, undisclosed principal and to the capacity that the agent is involved in the transaction, which takes us to the actions and remedies of the third person. Whew. A lot of stuff on this. We have their actions of a third person against the principal, going around the agent here. Principal may be sued on authorized agent's obligations. No demand upon agent required as a precondition. agent's violation of a prohibitive statute does not discharge the principal if contract is within agent's authority. So even if the agent violates a prohibitive statute, it does not discharge the principal. If that's within the agent's authority, if you told him to do something illegal, then you as principal would be it would not discharge. You would not be you would still be liable for that. Principal may not plead agent's wrongful act in defense of an action at law. Can't blame your agent for it. Punitive damages against the principal must show the agent had managerial status or the principal ordered or ratified the acts. So the punitive damages against the principal must show that the agent had managerial status, meaning that it was in their scope of authority, that the principal had the principal's blessing, or the principal ordered or ratified the acts. There's punitive damages. Then there's the disclosed, partially disclosed principal is not discharged by payment to settle with the agent unless in reasonable reliance on third-party conduct indicating agent settled the account. So that needs to be specified or an independent action, it seems there, for payment to settle. Finally, the judgment against the agent of a disclosed principal does not discharge the principal unless they're joint contractors. So there you go. This practices, they really get down to every detail, don't they? Principal is discharged to the extent authorized agent has satisfied the claim. Here's our supplement case here from SDJ Insurance Agency LLC versus American National Insurance Company. And that's from the 10th Circuit in 2002. Oh, here we go. Genuine issue of material fact existed as to whether insurance agent had implied responsibility to repay advances made to him by insurance company under agency agreement, precluding summary judgment. Even though agency agreement itself did not expressly hold agent personally liable for advances. So remember these terms from summary judgment. Genuine issues of material fact existed. So that would preclude the summary judgment. And it was whether the insurance agent had implied, this is a question of fact here, whether the insurance agent had implied responsibility to repay advances by the insurance company under agreement, precluding. So the implied responsibility makes it something that needs to go to be deliberated. Let's move along. So we have a third party against the agent. The third person may sue the agent in the contract where the instrument was executed so that the agent is personally bound. We saw that before. They're specifically bound by that contract personally that the third party enters into, then they can be sued. Unauthorized agent liable for breach of implied warranty of authority. The recovery is measured by real damages sustained. All right, so we can't be speculative here. This is show the receipts. Damages may include money paid or work performed, special damages, costs of unsuccessful action against the principal. Hey, this is practice and procedure. Every dollar counts, right? Third person has quasi-contractual action, the money had and received, where agent received money improperly and paid it to the principal with notice principal was not entitled to it. Sheesh. Then we also have, these are the remedies and actions against the agent. In contract action against the agent has all defenses arising from the transaction plus personal defenses, but not defenses personal to the principal. So that's when the actions against the agent, they can't be dragging the principal into this. With principal's consent, agent may set off any claim the principal might have set off in an action by the third person against the principal. So the principal can have your back as agent and say, no, you're suing the wrong guy. Here's the set off, discharge the agent. All right, let's look at section 335, limitation of the actions. Deceit action, which are false representations of authority. The statute runs from the discovery of the fraud. So lots of time, once you discover the fraud, that's your so-called statute of limitations starts running. Now we have the breach of warranty of authority action. The statute runs from the time plaintiff suffered the actual damages, not from the misrepresentation nor the discovery of the falsity. So it runs from the time they started suffering the actual damages. So this is the time it's supposed to be known. Actual damages, again, show me the receipts, not speculative or futures, actual. Now we get the parties for the defendant, the joinder of principle and action. So joinder is bringing others into the case, not to be confused with enjoin, which means to stop something from happening. But they do this just to fool. All right, third person dealing with agent of undisclosed principle may elect to sue one or both on the contract. So third person of the undisclosed principle. So if they're going to remain undisclosed, then it looks like the agent's on the line. When the election is made to sue one, the other is not a necessary party. So here you can elect to sue one or both, but when the election is made to sue one, the other is not. So you either do one or you do both. Where existence of agency is controversial, creditor may sue in the alternative against both alleged agent and undisclosed principal when the existence is controversial. Wow. And that's when they sue in the alternative against both alleged and undisclosed. In the alternative, generally, after full disclosure, third party may join principal and agent as co-defendants, but must elect against one prior to judgment. Wow. Action to reform on an instrument based on an agent's false fraudulent representations must be brought against the principal only. All right. The agent's false fraudulent representations are brought against the principal. An action to reform on an instrument. So, wow. So we have a written instrument that needs to be reformed. Formed again on the agent's false fraudulent must be brought against the principal. So the agent did something fraudulent. The actions against the principal to reform it. If that was the outcome or the remedy you're going for. All right, let's move along here. All right, now we're on to the pleadings. Generally in the necessity for plaintiff to allege agency in contract actions by or against the plaintiff. Plaintiff need not allege agency. Contract may be pleaded as if it were the principal's own contract. So it's probably judicially noticed and brought to the full knowledge of the court that it is indeed done through the agency. Under this rule, the agent, not even mentioned, need not be named or identified. There is an exception in some courts when the alleged principal is a corporation. The agent whose acts are relied upon must be named or effectively identified. Well, that makes sense. Gosh. All right, then we have the manner and sufficiency of pleading agency or authority. Allegations that defendant contracted by or through an agent are sufficient. There's your language, by or through an agent. Pleading that one contracted with another as or acting as an agent for the opposing party is sufficient. So you're pleading that this guy acted as or as. Defendant contracted by or through. See the language here. This is the sufficiency of pleading. Alleging one contracted with a person described as agent of the other party is sufficient, though there is authority to the contrary. Wow. So we want to specify the agent. The statement of agency in an allegation of ultimate fact need not explain how the agency originated. It's a statement of agency, is an allegation of ultimate fact. So this is a fact that needs to be tried. Some jurisdictions require factual pleading. Must plead facts that could establish agency, not merely the legal conclusion. So some jurisdictions, check your jurisdiction. The general averment of authority is sufficient. Specific facts showing authority need not be set forth. So a general averment. So you would have to make a statement of facts you know is true, is sufficient. Pleader who specifically describes authority undertakes risk that particular facts may be held insufficient, and seeking to hold agent personally liable on instruments signed in representative capacity. The pleading must contain allegations fixing personal liability. Okay, we're on to section 339, the allegation of ratification or estoppel. And for those that you have just arrived, just to remind you that we do have the talking chat enabled. If you have any questions or comments, clarifications, go ahead and type it in the chat.
The tribe says, hit the like.
Indeed, and it will read it back, and that way we can keep everyone along here. We have a very special treat coming up at the end, so make sure you stay tuned. Let's continue here. We're on the allegation of ratification or estoppel. Allegation of agency sufficient to admit ratification evidence in the main case or in rebuttal. The ambiguity in agency allegation may be cured by a ratification allegation in the same pleading. So the ambiguity may be cured by a ratification allegation in the pleading. We're talking about pleadings here. To plead ratification, here we go. Here's our ratification allegation. Our practice and procedures. To plead that ratification, you must use words supporting a technical ratification. Merely alleging receipt of benefits without alleging knowledge and retrospective consent is insufficient. So you need to do more than that. You need to allege knowledge of the ratification, right? These words supporting a technical ratification. It would be with alleging knowledge and retrospective consent, meaning that consent was given beforehand. That without that, it would be insufficient. So these are some of the things: the knowledge and the retrospective consent to that ratification or allegation of ratification or estoppel. Now, the estoppel against a principal is all representation, acts, and conduct relied upon to raise the estoppel must be specially pleaded before the evidence may be received. So let's move along here. Before we get too deep into that, let's move to the pleadings by the defendant. The principal seeking to avoid liability must deny both the authority and the ratification. The agent avoiding the personal liability need not specially plead that he acted as agent and disclose the principal, though there is authority to the contrary, so check your jurisdiction. So we're looking here again with the pleadings by a defendant, and this is a principal seeking to avoid liability. The principal must deny both the authority and the ratification. So, that's a pretty high bar here. Nonetheless, if it's true, it's easily reached. The agent defending suit by principal and claiming right to retain money as compensation must set up that claim by way of a counterclaim. Again, the set-offs, counterclaim, these kind of claiming the right to retain some money as compensation. That would be almost, that would be like the set-off. Now we have the pleading subsequent to answer. If the answer sets up new matter, it may be controverted by a reply. A case tried without a reply to a plea, the defendant treated on appeal as having waived the plea. And a statute may provide that agency authority allegations pleaded as new matter in reply are deemed automatically controverted by defendant. No further pleading or affidavit required. So there it is. The agency authority allegations pleaded as new matter in a reply are deemed automatically controverted by the defendant. No further pleading or affidavit is needed. So that's different ways to see how the different aspects of second here. All right, there we go. Come on, let's go to the next one. All right, now we're on to one of the best parts here, evidence. Okay, there we go. We're back. So, section 342, burden of proof. The party asserting the agency bears the burden of proving its existence, nature, and extent.
Lex Animata says no sound.
Is it back now? Testing 1, 2.
Lex Animata says okay, all good now.
All right, thank you. Okay, so we have the party asserting the agency bears a burden of proving its existence. Ostensible agents must prove 1, the principal's conduct caused the reasonable belief of agency, and 2, justified reliance on apparent agency. So there's 2 things. We have an and. So to say, oh, of course he was the agent. It was the principal's conduct. He said, hey, that's my guy. It caused a reasonable belief of the agency, and there's a justified reliance on the apparent agency. Well, he was wearing a tag that had the principal's name on it, right? A party dealing with agent must prove the agent's authority to bind principal by the act or contract in controversy. So how do we do that? That's through the terms of the agency, the contract or the agreement of the agency there. That will have a scope of authority in there. Undisclosed principal. The third party has burden of proving it was unaware of the agency-principal relationship. Wow, so you got to prove you didn't know. And the agent trying to avoid liability. The burden of proving agency relationship and principal's identity were in fact disclosed. So they have the burden. Okay, so an agent trying to avoid the liability has the burden of proving the agency relationship and principal's identity were disclosed. Because if it was undisclosed, the agent's on the line, remember. Okay, let's look at the supplement case here of Lopez versus El Palmar Taxi Incorporated. And it looks like Georgia Appellate Court, 2009. The fact of agency may be...
Minecraft Fafo says hit a like.
Yes, sir. Please hit the like. And greetings to you, Minecraft. All right, so the fact of a...
Minecraft Fafo says, F-A-F-O-I-M this bit.
Yeah, FAFO. All right, the fact of agency may be established by proof of circumstances, apparent relationships, and the conduct of parties. That's your ostensible agency. IRA Resources Incorporated versus Grigio in Texas, 2007. Texas law does not presume agency, and the party who alleges it has the burden of proving it. Wow. So you see different jurisdictions view this differently. So let's look at part 2, the burden of proof. The burden of proving revocation or termination of agency is on the party asserting it, where plaintiff may rely on presumption of agent's implied ostensible authority. Defendant bears the burden of proving the agent lacked that authority, and the plaintiff knew it. That's where the plaintiff may rely on the presumption of the agent's implied authority here. Where the plaintiff relies on the defendant bears the burden of proving the agent lacked the authority, and the plaintiff knew it, The burden of proving ratification and the principal's knowledge of all material facts is on the party alleging the ratification. There you go. An agent seeking compensation must prove the principal's promise to pay and the agent's own performance. They must prove they performed and prove there's a promise to pay. An accounting action. Principal bears burden of proving agent received funds, property, and the amount. The agent bears the burden of proving proper disposition of amounts received on principal's behalf. So basically, I guess the principal would have to show he had credits going to the agent, and the agent would have to show that the principal has received the debits. Everyone's going to check their books here and see what's going on. So we're on to presumptions and inferences. No presumption of agency from parties' acts alone. So the parties acting, just pretending you're an agency or an agent isn't enough alone. It must be proved unless arising by operation of law. So check your jurisdiction. Evidence of principal approving unauthorized acts capable of ratification. So the evidence is sufficient, absent contrary evidence, to raise a presumption of ratification. So there's evidence of principal approving unauthorized acts capable of ratification. Interesting there. So I'm trying to think here, what examples could we think of that have evidence of a principal approving? What kind of unauthorized act would they do? But I'm trying to think here. So let's see, he's approving unauthorized acts capable of being approved. Absent contrary evidence. Well, we'll have to think that one through there. Once established, the agency is presumed to continue in the absence of revocation or termination. So we have the continuance of conditions here, right? This is a principle. So once established, it's presumed to continue in the absence of any evidence to the contrary. Agent in course of disclosed agency. So we know about the parties here. Presumed to obtain credit for principal exclusively. The burden is on the party asserting otherwise. Okay, so it's disclosed agency. And the negligence or misconduct of agent will not be presumed absent proof. So you can't.
Definitely says, not acting in the Benny's best interest.
Yeah, in this case here, it's just an agent-principal relationship. So again, this is strictly in that context here. So we have the negligence or misconduct of agent will not be presumed absent proof. So bare allegations are not enough. So there will be no presumption of misconduct unless there's proof. And husband-wife relationship does not, per se, raise a presumption that one acted as agent for the other. Although most cases it is presumed that way, but it does not per se raise that presumption. In certain circumstances, perhaps. But let's look at the supplement cases here with Kirshner versus KPMG LLP in New York 2010. Agency law presumes imputation even when the agent acts less than admirably, exhibits poor business judgment, or commits fraud. So I think imputation is relating to impunity and such, if I'm not mistaken. Let's see, change a claim that someone has done something undesirable. So it's an accusation. So it's presumes an accusation someone did something bad even when the agent acts less than admirably, exhibits poor business judgment, or commits fraud. So high standard for that agent. Then we have IRA Resources Incorporated versus Grigio again. In Texas 2007, Texas law does not presume agency, and the party who alleges it has the burden of proving it. So that case shows up a lot. Presumptions as to agent's authority. So let's look at this one here. If the agent is uncontroverted and the agent was apparently acting for principal in the business at hand, the agent's presumed to have acted within the scope of authority. Where agency is proved without showing its extent, general authority presumed as to the relevant business. So again, scope of authority, we're looking at presumptions here. So we don't really see it, but there's presumptions that they're working within the scope of authority without actually having to bring it to proof of facts here. And where it's proved without showing its extent, then they only have general authority. So if it's only proved without showing its extent or that scope of authority, but it's proved there is an agency relationship, the general authority is presumed as to the relevant business. So that's the essence of that presumption. If general authority established, which we show here how it can be done just by having an established relationship proved, but not necessarily the scope of the authority. So if the general authority is established and an act is not unusual, extraordinary, then the agent is presumed to have had authority for that act. So nothing extraordinary or unusual. Authority to execute a deed may be presumed from receipt of purchase money plus the vendees taking possession under the deed plus possession held for a number of years. Interesting here. These are all requirements. The authority to execute a deed may be presumed from the receipt of the purchase money. Remember, these are rebuttable, plus the vendees taking possession under the deed and the possession held for a number of years. So these establish presumptions, not proof. And we get to where one sells and others land under assumed authority. The prima facie evidence of authority as between principal and agent. Interesting one there too. Okay, let's move along. So let's get to that proof. We've gone through the presumptions. So let's look at the proof of agency relationship. And the agency may be proved by direct evidence of express contract of agency, of course, because that will have the written scope of authority. Competent evidence tending to prove agency, or circumstantial evidence, but not by conclusory, unsupported allegations. So you can't prove the agency relationship. You can only presume it by conclusory, unsupported allegations, and even that's a stretch. One view is that a jury may weigh all evidence and draw reasonable inferences, even if both principal and agent categorically deny agency. Wow. Wow, so the jury may weigh all the evidence and draw reasonable inferences. The other view is a mere suspicion or bare assumption of agency has no probative value. So the agent's general reputation as agent admissible to prove apparent agency elements, not actual agency. So it could give reason to believe, but it's not actual agency. Marital status cannot in and of itself prove the agency relationship, but it would be a strong point. But in and of itself, it's not. Parole evidence rule, prior or contemporaneous oral agreement on duration of agency contract is inadmissible where the written contract exists and is silent on duration. So, having that oral agreement when there's a written, the written is always going to override the oral. So let's move along. Now we have the proof of authority or the ratification. The actual or apparent authority may be established by circumstantial evidence. Actual or apparent may be established. All circumstances, including prior conduct of principal and customs usages of business, may be considered on the issue of implied authority. This all makes perfect sense, right? In practice, because certain businesses have certain kinds of agents, it's expected and it's customary. And that's in their typical usage of business. And then there's also prior conduct. There's been many transactions done faithfully as agent principal with this, you would expect that to continue absent any other evidence. Principal's acquiescence in, recognition of, or adoption of similar prior acts by the agent, the evidence of authority. Then there's a ratification, express or implied, may be established by circumstantial evidence. So he was always saying, yeah, I approve of him. Ratification must be clearly shown, either directly or impliedly, from clear and unequivocal circumstances. Ooh, so a pretty high bar there. And parole evidence, just direct testimony or proof of surrounding circumstances, is admissible to establish authority where no written instrument evidences it. So then, if there's no written evidence, now you can bring in that oral testimony and such, and it can be admissible. Or I should say it would be admissible. But let's get to that testimony, the testimony of the agent. So we have the agent's extrajudicial statements are not admissible to prove the fact of agency. So if he's not saying it before the court, those other statements are not admissible. The agent's trial testimony is admissible on the existence, scope, and extent of the agency. The agent is a competent witness to prove or disprove their own agency. On disputed authority, the agent may testify concerning that matter. Agent may also testify about the authority of a co-agent of their common principle, based on personal knowledge. And neither fact of employment nor agent's own representations, per se, establish the scope of authority. So the scope of authority has to be expressed. It's not something that's empirically figured out like that. We have the caution here, the uncorroborated testimony, and there's no one else backing this up here, of an alleged agent. It's not sufficient to prove his or her agency relationship. Further, a purported agent cannot unilaterally create an apparent agency through his or her own words or conduct. Yes, I'm the agent. Anyone else can corroborate that? No, but I'm stating it. That won't get you very far, it says here. It's not through their own words or conduct. Look, I'm acting as an agent. But no, that won't work in the court.
Lixanimita says, bingo, this is such a great slide.
Great, enjoy. Take a screenshot if you wish. I'll throw it back for a second, and we're going to move on to the next because we're almost to the best part of all. But this is where your testimony really matters here of an agent. All right, so now we go to evidence of extrajudicial statements of the agent and the restatement second of agency law here. The agent statements are admissible for and against the principal if admissible under general evidence rules. The agent's admissions declarations other than trial testimony, though, are not admissible against a principal to prove agency or its scope. So those testimonies about the scope of authority or the relationship are not admissible. The agent's extrajudicial, we say extrajudicial is anything outside of the court there, not under oath. So the agent's extrajudicial statements may not prove the agent's authority to bind the principal. And declarations of the agent may be admissible, one, to corroborate other testimony showing agency, or they can use to corroborate but not to establish, especially on its own, or two, to determine whether a third party dealt with alleged agent as agent or as principal. So were they dealing with the agent as the agent is in his personal capacity or as his agency capacity for the principal? So that's the declarations of the agent he can state there, and that will be admissible, at least as some evidence. Now the debate is, once agency is established by competent evidence, some courts hold that statements on scope are still inadmissible. Others admit them to bind the principal. Ooh, so check your jurisdiction again. And here we have some supplements here that the state of Pruin Axman Propane Incorporated in Montana, 2009. The declarations of an agent made outside the presence of a purported principal or not authorized or ratified by the principal cannot be testified to by a third person for the purpose of proving the scope or extent of the authority of the agent. So the agent, whatever he's saying outside the presence of the purported principal or authorized, the declarations were not ratified or authorized by the principals, it cannot be testified to by a third person. They can't say that's like, oh, hearsay, I guess is what that would be there. That's all right, from Montana 2009. Let's look at the caution here. The preliminary proof of agency requisite to render the statements of the purported agent admissible against the principal must be made by evidence other than the declarations of the alleged agent. So you can't just come in there making bare claims. You need to come in there with some evidence. And evidence as to agent's acts or conduct. So let's look at this. As we see here, the practice and procedure, we're just getting to the nuts and bolts of what makes these things work smoothly in court. And as you can see here, this all ties into the previous presentations we've done on agency. So competent witnesses may testify to what agent did, but may not state the inferences drawn from those facts. They testify what the agent did, but can't say why they think he did what he did. Acts alone cannot establish agency unless they are continuous and of such character as to justify inference that principal knew and assented. One court says the inference from actions alone has no probative value to establish agency. Wow. Generally, the agent's authority may not be shown by evidence of agent's own acts. So the agent's authority can't be shown by his own acts, others' acts recognizing his authority perhaps, but generally. Nor may extent of authority be shown by acts not within actual or implied scope of powers granted by the principal. The implied, actual or implied scope of powers. After agency is prima facie established, the agent's acts within the actual or ostensible authority are admissible to bind the principal. And what agent did with the principal's knowledge and approval is circumstantial evidence of what the agent was authorized to do. So what he did, those acts are circumstantial evidence. So again, that's only part of the picture there when you're trying to prove that agency relationship or scope. Now let's get on to the conclusion or opinion of witnesses as to agency or authority. So the general rule, witnesses may not testify to the existence, non-existence of agency as a conclusion or ultimate fact. The exceptions when the statement is essentially a statement of fact within that witness's own knowledge. So it can be stated as a statement of fact, but it's not as a conclusion or ultimate fact. And we have witnesses may testify as a fact that he or she was or was not agent of a certain person. Third-party witnesses may testify that the relationship did or did not exist as a statement mainly of fact. So these statements of fact can be entered in there to be considered, but they in and of themselves are not presented as anything conclusory or ultimate facts. Testimony of facts going to show existence, non-existence of authority is admissible. So testimony of facts going to show. So it's not the just a general testimony to the existence. It's testimony of facts. So the testimony, like you saw in this first one, is to existence or non-existence of agency. It's not allowed to be used for anything relating to the ultimate facts, the facts that will decide the outcome of the case. Okay, so we see how we're breaking this down here. So but witnesses generally cannot testify that he or she or another did or did not have authority for particular purposes. They can't state that. They can only state statements of fact of what they know, what they've seen, not what they infer or their conclusions. Witnesses may testify as to another's duties, but may not give an opinion on whether that person performed those duties. Wow, so there's no assessment needed from the witness. Thank you. All right, now we get to the parole evidence to establish principal or agent as a party to a written contract. The principal may introduce extrinsic evidence to show contracting party executed as agent. It does not contradict the writing. It explains the transaction. See? Then the restatement second, if contract specifically excludes principal, parole evidence is inadmissible. If contract specifically makes principal a party, parole evidence inadmissible to show otherwise. Then the agent's personal liability depends on the manner of executing the instrument and the intent to be bound. Where the instrument is ambiguous, parole evidence as to parties' intentions is admissible. So, of course, with the ambiguities, you want that parole testimony, the oral testimony, because you get nothing else. Where instrument is not ambiguous, or the agent seeks to escape liability as undisclosed principal, parole evidence is inadmissible to contradict terms, so he can't squeal. Agent, the principal's undisclosed. The agent can't squeal and get out of it with his parole evidence or testimony to contradict. Where an instrument is not ambiguous, the instrument, written instrument, let's say here, is very clear about who's liable here. Agent may introduce extrinsic evidence to show name was signed as business name of principal and party so agreed, or to reform the contract. So they may introduce evidence to do that. Oof. Supplement here from the restatement second, section 323.2. If the fact of agency appears in an integrated contract, not sealed or negotiable, wow, and there is no unambiguous expression of an intention either to make the agent a party thereto or not to make him a party thereto, intrinsic evidence can be introduced to show the intention of the parties. There's no unambiguous expression, nothing sealed or negotiable, integrated. Okay. Then we have section 323.1. I don't know why it's before this, but if it appears unambiguously that an integrated contract that the agent is a party or is not a party, extrinsic evidence is not admissible to show a contrary intent except for the purpose of reforming the contract. Whew. All right, so establish principal or agent to the party of the contract. Better to just get these terms clear in the contracts. All right, this takes us to my favorite part of this is the questions of law and fact before we get to our special treat, which will be next. So make sure you stay tuned here. Coming right up. So let's get to our questions of law and fact. Undisputed facts. No conflicting inferences mean, therefore, the question of law for the court. So let's look at this. There's undisputed facts. There's no conflicting inferences. That makes it a question of law for the court. Conflicting facts or conflicting inferences may be drawn from evidence, makes it a question of fact for the jury or court if it's the court's a trier of fact. The weight of evidence to show agency is a question for the trier of fact. To the weight of evidence to show that goes the trier of fact. So no summary judgment there when that's the thing, but there's undisputed facts and no conflicting inferences. It's strictly a question of law for the court. Whether the principle is partially or completely disclosed is a question of fact. So these have to be established through the trials. Whether agent has bound himself or herself personally is a question of fact. That's a question of fact for the jury or the court as a trier of fact. Now we get to the extension of credit. the breach of duty, disclosure, ratification, and repudiation. Whether a credit was given to an agent of disclosed principal alone, okay, the disclosed principal is a question of fact for the jury. Whether an agent breached his or her duty is a question of fact. Whether the fact of agency and the principal's name were disclosed known to a third party, protecting the agent from personal liability, is a question of fact. The jury's going to decide whether it was disclosed or not. No matter what anyone says, no matter what anything else matters there, that's a question of fact if there's a dispute. Whether the facts show ratification is generally a question of fact, but it's a question of law for the court, only where facts are undisputed. So there you go. If it's undisputed, then perhaps it can be just for the court as a question of law. And whether repudiation was within a reasonable time is a question of fact. So see how this maps out here? Let's move along here. Now let's look at the nature and extent of authority. The conflicting evidence or differing reasonable inferences means the nature and the extent of authority is a question of fact. Apparent authority is a question of fact. Undisputed evidence with no differing reasonable inferences means that that authority is a question of law for the courts, not the jury. Whether a particular act is within an agent's authority is a question of law if evidence is undisputed. So if we know the agent's authority, then it's a question of law. The construction of written power of attorney or written agency contract is a question for the court unless ambiguous and dependent on conflicting extrinsic evidence. But if there's clear construction of written power or written power of attorney, that's for the court. That's a question of law, how it applies. If ambiguous instrument, though, the jury determines the disputed facts. The court construes in light of the jury's determination, or the court may submit interpretation to jury under proper instructions. And whether the third party had notice of limitations on agent's authority is ordinarily a question for the jury. Question of fact there, and revocation of authority and notice thereof to one subsequently dealing with the agent. So the revocation of authority is a question of fact for the jury. All right, this takes us to the best part of the presentation for those that stayed. We get to do our fun quiz here and take our knowledge check. Here's how we play this game. We start with the question number, and in the chat, put in the number of the question you're answering and the choice of your answer letter. So if question 1, I was choosing answer D, I would put in the chat Arabic number 1 followed by the letter D, delta. That'd be my choice. If I choose to change it, I would put the changed letter in there after the same number 1. So it'd be 1 changed letter. If it was B, beta, that'd be there for Bravo. Okay, so let's move along here with question 1. An agent collected $10,000 for the principal, but he secretly skimmed $2,000 and paid the principal $8,000. The principal accepted and deposited the $8,000 without objection. Which of the following is true? A. The principal's acceptance constitutes accord and satisfaction, barring recovery of the $2,000. B. The principal may still recover the $2,000 because acceptance of a partial payment is not in accord and satisfaction. C. The principal's only remedy is in equity, not in law, because the agent is a fiduciary. Or D. The principal must first make a formal demand before any cause of action accrues. So which of the following is true in this situation here? Agent collected $10,000 for the principal, but he secretly skimmed $2,000 of it, paid the principal the remaining
Lexanimita says 1B.
All right, we got 1B in there. Sounds reasonable. Any other choices here for question 1? Anyone else wants to take a stab at it? No, we're going to move on to question 2. Question 2. A third party contracts with an agent, unaware that the agent is acting for a hidden principal, the undisclosed principal. The principal later sues on the contract. At the time the contract was signed, the party owed the agent $5,000 on an unrelated debt. Can the party set off that $5,000 against the principal? Ooh, look at this. So in this situation here, we have an agent, right? The third party owes the agent $5,000, and the third party is unaware the agent's acting for this principal. The principal later sues on the contract, and the contract the third party was entered into owed the agent $5,000. But here's the can the third party set off that $5,000 against the principal? So the principal's suing on a contract. The third party owed the agent $5,000 on an unrelated debt. So, being that the third party owed the agent, can the third party set off the $5,000 against the principal? No, the set-offs against agents are never available against the principal under any circumstances. B, yes, but only if the debt existed at or before the time the principal's identity was disclosed. C, yes, any personal debt owed to the agent can always be offset by the undisclosed principal. Or D, no, the third party had a duty to inquire about the existence of a principal before contracting. All right, so the third party owed the agent $5,000 on an unrelated debt. So can the third party set off the $5,000 against the principal? Principal suing.
Great for EG5E says 2D.
All right, 2D. I'm going to choose 2D. Now, what we're trying to say, it seems a little bit confusing here because it is. The principal was undisclosed, and here he's coming to sue him now. So here's a guy out of nowhere coming to sue, saying that this contract here. However, there's already $5,000 that is owed to the agent, and now this principal is suing, and he figures this is the same guy, so he can't sue. What if the $5,000 is part of that contract or something else? Is he going to have to pay twice? So this is what I think it comes down to. Can the third party set off that $5,000 against the principal, or is he still have to pay it to the agent, irrespective of this suit that the principal is now holding against him? Let's move along here. Any other takers for question 2? We're going to move to question 3. Question 3. At a trial, a plaintiff calls an alleged agent to the stand. The agent testifies, "I was definitely acting as Smith's agent. He told me so himself, and I always introduce myself that way to clients." No other evidence of agency is introduced. What is the evidentiary problem here? A, an agent is incompetent to testify about agency at all. Only the principal may establish the relationship. B, the uncorroborated testimony of the alleged agent alone is insufficient to prove the agency relationship. The uncorroborated testimony. No other evidence. Okay. The agent's self-introductions to clients constitute apparent agency and are sufficient corroboration. Or D, the agent's trial testimony is inadmissible hearsay when offered to prove the fact of agency. All right, so probably 2 reasonable answers here. Anyone want to take a stab at question 3? Question 3, going once, going twice, going 3 times. It's a hard one. All right, we're going on to question 4. Question 4. A written, unambiguous contract clearly identifies Jones as the contracting party with no indication of agency. After a dispute arises, Jones claims he signed purely as an agent for an undisclosed principal and seeks to introduce parole evidence of a prior oral agreement confirming this. The court should A. Admit the evidence. Parole evidence is always admissible to clarify the identity of parties to the contract. B. Admit the evidence. The undisclosed principal exception permits extrinsic proof in all agency cases. C. Exclude the evidence. Where a contract is unambiguous, an agent cannot introduce extrinsic evidence to escape personal liability as an undisclosed principal. Or D. Exclude the evidence. Oral agreements modifying written contracts are void under the statutes of fraud. All right, so we got some pretty good answers on this one. This is a tricky one. It's a written, unambiguous contract that clearly identifies Jones as the contracting party, but it has no indication of agency.
Grade per EG5E says 4C.
All right, we got a 4C. That the exclude the evidence where the contract's unambiguous, an agent cannot introduce extrinsic evidence to escape that personal liability as an undisclosed principal. So we see here, he signed purely as an agent. He's claiming this, but there was no indication of agency at the time of signing. So what would the court do? Is exclude his evidence, is what you're saying here for C. All right, let's move on to the answer slide. All right, so for question 1, the agent collected $10,000, skimmed $2,000. The correct answer was B. The principal may still recover the $2,000 because acceptance of partial payment is not in accord in satisfaction. And that came from section 325. The principal's acceptance and retention of partial payments does not constitute an accord in satisfaction, precluding recovery of the balance. All right. And I believe we get this one. I want to get this one right here. Excellent. Let's move on to question 2. Third party contracts with the agent, unaware the agent's acting for a hidden principal. The principal later sues. This was a complicated one here. The $5,000 debt was owed to that agent. Can the third party offset it? Yes, but only if the debt existed at or before the time of the principal's identity was disclosed. So the correct answer was B. A defense or set-off against an agent must have existed at or before the time of disclosure to be available against the undisclosed principal. So being it was undisclosed at the time, then he's dragged the principal into this because it's hard to, who could it know that you're not acting any differently, agent or personal capacity, without it differentiating and without the scope of authority saying that, then yeah, there it is. Now we get on to question 3. At trial, plaintiff calls an alleged agent to the stand. The agent testified, I was definitely acting as Smith's agent. He told me so himself, and I always introduce myself that way to clients. But there's no other evidence of agency. So what's the problem here? Evidentiary problem. Is B. The uncorroborated testimony of an alleged agent alone is insufficient to prove the agency relationship. So the caution that we read over here, the uncorroborated testimony is insufficient. No one's going to believe you're going to say everything and there's nothing to corroborate it. That's, Okay, that takes us on to C. Do we answer on 3B? Let's see. Okay, let's move along here. Next question was question 4. The written unambiguous contract clearly identifies Jones as a contracting party with no indication of agency. So this third party signed this contract, but the dispute arises. Now Jones claims he signed it as an agent and seeks to introduce parole evidence of a prior agreement confirming this. The court should do what? C. Exclude the evidence. Where a contract is unambiguous, an agent cannot introduce extrinsic evidence to escape his personal liability as an undisclosed principal. And of course, that was a good one there. And we got that one right as well. All right. Well, salute to all of you that have been through this. This has been an important presentation here to really get a good feeling for the practice and procedure involving agency laws. We went over the actions and remedies, pleadings, evidence, and of course the questions of law and fact, sorted all those out. So I hope this gives everyone a much better understanding of agency and how this works, because this is something that occurs in our day-to-day lives in many different facets, and it behooves us all to be skilled and at least knowledgeable to some extent with the way this functions in our society, so to speak, both the legal and the civil sides. And with that said, I thank you all for attending, and I hope to see you all on the next one. Peace out.
Audit them says, thanks. Lix Animita says thanks the tribe. That was a detailed and interesting broadcast. I appreciate ya and the proper instruction efforts ya brings.